Good day everyone, welcome back to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule, and in today's episode we will unpack what if an employer initiating a retrenchment process fails to issue a section 189 subsection 3 letter. Will the retrenchment be considered fair? In the context of retrenchments, the issuing of a section 189 subsection 3 notice in terms of the Labour Relations Act is commonly regarded as a critical initial step. This notice acts as a formal invitation to engage in consultations about the proposed retrenchments and provides consulting parties with essential information such as the rationale for retrenchment, alternatives considered, proposed selection criteria, severance packages, and anticipated timelines. These topics typically set the agenda for consultation meetings. In the matter between Pariache vs. Serrero, the Labour Court was tasked with determining whether a section 189 subsection 3 notice is always essential for retrenchment to be procedurally fair. In 2019, the Joburg Property Company undertook a restructuring exercise that affected various positions, including that of Ms. Pariache, the employee, who was the head of IT. Her department was deemed unable to provide the necessary strategic IT advice, prompting the restructuring. The new corporate structure was discussed at the company's executive committee, where Ms. Pariache was present, and later approved by the local labour forum, which included her trade union, Imatu. Despite these discussions, neither Ms. Pariache nor Imatu received a formal section 189 subsection 3 notice. Ms. Pariache was ultimately dismissed for operational reasons on the 30th of September 2019. Disenchanted by her dismissal, she challenged the fairness of the dismissal at the South African Local Government Bargaining Council, which upheld its fairness. Ms. Pariache then took the Council's award on review to the Labour Court, where she argued that the company's failure to issue a section 189 subsection 3 notice violated section 189 of the Labour Relations Act. On the issue of substantive fairness, the Labour Court held that section 188 of the Labour Relations Act prescribes that a dismissal is substantively unfair if the employer fails to demonstrate that the reason for dismissal is fair and is based on operational requirements. To be substantively fair, the reason for retrenchment must be bona fide, rational, and supported by a valid business or commercial rationale. The Labour Court agreed with the Commissioner that the restructuring was necessary due to operational requirements. The Labour Court held further that the company's decision to eliminate the IT department and offer Ms. Pariache an alternative position, which she declined, was considered reasonable. The court concluded that the dismissal was substantively fair as it met the legal and business rationale requirements. Regarding procedural fairness, the Labour Court observed that fairness is generally tied to compliance with Section 189 of the Labour Relations Act, which includes issuing a Section 189 subsection 3 notice. However, the Labour Court acknowledged that the unique circumstances of this case justified the omission for the following reasons. The proposed changes were discussed with the local labour forum, where Ms. Pariache's trade union, Imatu, participated and in fact supported the restructuring. The company communicated directly with Imatu, explaining why it believed a Section 189 subsection 3 notice was unnecessary, and neither the union nor the employee raised objections. The Labour Court determined that despite the absence of a formal notice, which is mandatory in terms of Section 189 subsection 3 of the Labour Relations Act, the company had substantially complied with the consultation process as outlined in Section 189. And as such, the meaningful and joint consensus-seeking process was not necessarily dependent on the issuing of a Section 189 subsection 3 notice. Moreover, Imatu also held the view that there was substantial compliance with Section 189. The Labour Court held that the Commissioner's findings were unassailable as they fell within the bounds of reasonableness. Thus, the dismissal was deemed procedurally fair. Key takeaways for employers. The Labour Court emphasised that this ruling should not set a precedent for employers to neglect issuing Section 189 subsection 3 notices. Each case must be evaluated on its merits, and they focus on whether there was substantial compliance with the consultation requirements. Section 189 subsection 3 notices remain crucial for ensuring meaningful engagement, providing evidence of consultation, and initiating consultation timelines, particularly in large-scale retrenchments. Employers are strongly advised to adhere to the section's requirements to avoid disputes over procedural fairness. Colleagues, that brings us to the end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.